Having established that the defendant owes the plaintiff a duty of care, we can move on to the second overarching requirement, right? And that is that the defendant actually breached that duty of care. The way to do this, or where this law is located, is actually in Section 9 of the Civil Liability Act. So why don't we see what that section of the Act actually says? So to give us an idea, here I am at Google, and if we want to find a piece of legislation, right, I can just put in the title that I'm after, the Civil Liability Act of Queensland, because that's the jurisdiction that we're after. And if I click through, because the law is now available online, it's very accessible, I can look at the particular section we're interested in here, Section 9. Section 9 has two parts. Part 1 sets out the requirements for a breach. So a person does not breach a duty to take precautions against a risk unless the risk was foreseeable, that is a risk which a person knew or ought reasonably to have known, and the risk was not insignificant, and in the circumstances a reasonable person in the position of the person would have taken precautions. So there are three things to establish if we want to establish a breach: that the risk is foreseeable, that it's not insignificant, and that in the circumstances, a reasonable person would have taken precautions. Now, what you might see here is that we have this Part 2. What does this Part 2 do? This Part 2 explains the test for Part C, for 1C. It says a reasonable person would have taken precautions against a risk of harm if the court considers the following and then makes its decision. So this is what the court has to consider to work out whether a reasonable person would have taken precautions. They've got to look at the probability that the harm would occur if care isn't taken, the likely seriousness of the harm, the burden of taking precautions, and the social utility of the activity. So 9.2 is the way we interpret 1C. Okay, let's get back to our slides and go through them. So as we've just seen, a breach of duty occurs when the risk is foreseeable, that is, it's a risk which the person knew or ought reasonably to have known. The risk is not insignificant, and in the circumstances, a reasonable person in the position of the person, of the defendant, would have taken the precautions. Risk is foreseeable, so if the risk is not foreseeable, then there's no breach of the duty. The risk was not insignificant. Now, this is one of those classic cases where the law uses a double negative. It doesn't need to be a significant risk. The risk needs to be not insignificant. Okay, so a case that might help you think about that is Bolton and Stone. We don't need to remember this, but in Bolton and Stone, what you had was a cricketer who hit the ball out of a ground, and it actually hit someone and harmed them. The court looked at, how often that occurred, and they'd said, well, it had only happened a few times over the last, 20, 30 years. In that case, the risk of hitting the ball out of the grounds was considered insignificant. So there's a level here about probability that we're talking about, along with harm as well, right? So if it's very, very minor, then it would be an insignificant risk. So it's some combination here. What we've got to make sure is that the risk is not insignificant. Okay, it has to have some significance. The final part of the test is deciding whether a reasonable person in the position of the defendant would have taken precautions. That's where 9 subsection 2 helps us. What it says is to work out whether a reasonable person would take precautions, you look at 4 factors. Now, it's not saying all these 4 have to be met or that we emphasize one more than the other. It's that you look at the 4 factors, and as a result, what do you think a reasonable person would do? So the first thing you need to look at is the probability of the harm. Obviously, the more probable or the more likely that the harm would occur, the more likely a reasonable person would take precautions. We then look at the seriousness of the harm. And again, the higher the seriousness of the harm, or the more serious the harm, the more likely a reasonable person would take precautions. Now, this is where it gets interesting. The burden of taking precautions. This is probably the most critical element of this test. The others are important, but this is the one that the courts look at. And what they're saying is, well, how much would it take for the actual defendant to take precautions? If it's going to be an outrageous amount, then they're going to say, well, look, a reasonable person wouldn't take precautions. So a case that might help us with that is the Roads and Traffic Authority of New South Wales and Dedera. So what we had were youths who used to dive off a bridge into some shallow water. One dove off and actually injured themselves severely. And then they sued the council for not taking precautions. So in this case, the probability of someone hurting themselves would be fairly high. Seriousness, very serious. You could break your neck or kill yourself. However, the courts looked at this and said, look, there were already signs on the bridge saying don't jump from it. And the costs for fencing the entire bridge to stop it were huge. So they said that burden of fencing the entire bridge was too large for a reasonable person. So a reasonable person would not have fenced the bridge. And in this case, they said that a reasonable person wouldn't have taken any more precautions than what the council did. So remember that they did have signs saying not to do it, etc. Okay, so we can see here that the courts are willing to look at how hard it is for the defendant to have actually taken the precautions. The harder it is to take precautions, the less likely a person would actually take those. A reasonable person would take those precautions. The final factor we look at is the social utility of the activity. So the courts are also willing, as a matter of policy, to say, sometimes we're going to say that a reasonable person wouldn't have taken precautions if overall society would be better off if they didn't take those precautions. This is classically used in situations like emergency responses. So in Watt and Herefordshire County Council, we had a fireman responding to an emergency, and they took the wrong kind of jack in order to go to the car accident and help. And because they had the wrong kind of jack, it actually led to an injury. So in that particular instance, they did owe a care. They had breached that duty. They did owe a duty of care. They'd breached the duty of care. But in this instance, the courts are saying, look, we don't want to put fire people, police people, maybe lifesavers off responding and worrying too much about being negligent before they respond. So in this particular case, the social utility of the activity, the good to society, outweighed the negative in terms of not taking enough care. And they said in this instance that the person hadn't breached their duty of care. One way to think about it is to say, look, if the defendant could have done something that's relatively simple, then if they don't take the precautions, they're likely to have breached it. Again, it's a balance with the harm and probability and the burden that would be required of them. And also we note that if they're doing something socially useful, then it's less likely that people will breach their duty. So just to summarise again, what's required under Section 9 for a breach is that the risk is foreseeable, it's not insignificant, and a reasonable person in the position of the defendant would have taken precautions. To work out whether a reasonable person would have taken precautions, we look at the probability of the harm, the seriousness of the harm, the burden of taking precautions, and the social utility of the activity that creates the risk. If we establish someone owes a duty and that they've breached the duty, we can move on to the third element of the test, which is, did the breach cause the harm, in our next video.